This is iChooseLife News and Views, sponsored by Indiana Right to Life and Allen County Right to Life, committed to defending innocent human life for all people of all ages. Your hosts are Cathie Humbarger, Abigail Lorenzen, and Scott Kump.
Welcome to iChooseLife News and Views. I'm Cathie Humbarger.
I'm Abigail Lorenzen.
And I'm Scott Kump. iChooseLife News and Views is a joint project of Allen County Right to Life, Indiana Right to Life, and Bot Radio Network in Fort Wayne, Indiana.
If you or someone you know is in a crisis pregnancy, help is just a phone call away. Call 877-791-5475. If you or someone you know is dealing with grief and pain after an abortion decision, call 877-791-5475. You'll be referred to a pregnancy resource center in your area, a place where free and confidential services are available. That's 877-791-5475.
Today, I have a very special guest. It's my privilege to introduce to you first-time guest on this program, but longtime friend, Attorney General Curtis Hill. I'll give you a little bit of information about him, and then we'll welcome him to the show. A native of Elkhart, Indiana, General Hill is the youngest of 5 children, and he credits his parents, Curtis Sr. and Eleanor, as his inspiration toward public service and leadership. It was during law school that he met his wife, Teresa, and together they're raising their 5 children, Haley, Mallory, Curtis III, Isabella, and Abraham. Prior to his election as Attorney General, he was the Elkhart County prosecuting attorney, where he was relentless in his pursuit of justice, and that has not changed one bit. In my personal experience with General Hill, I've found him to always be ready to listen and always be ready to let me know if I have a valid argument or not. And a little interesting tidbit, in case you're ever asked this question in a trivia game, on November 8th, 2016, General Hill was elected to his position in record-breaking fashion. More than 1.64 million Hoosiers cast ballots for him, which is more than any elected official in Indiana history. Welcome, friend. We're so glad to have you with us.
Thank you, Cathie. It's great to be here.
Well, I just want our listeners to know that you have been steadfast in making certain that the life issues that come through your office are taken very seriously and vetted, and the action that you take is based on reality and not what we might hope will happen. So I'm really excited about having you on the program today. We have a lot to discuss, but let's begin, if it's okay with you, with a simple explanation of your responsibilities as Attorney General.
Well, that's a very good question because a lot of people don't understand what goes on with the AG's office. And first and foremost, people need to know that I have my own personal belief system, but as the state's top lawyer, it's my responsibility to represent the interest of the state. And so one of the most important things to understand about my job is I have the responsibility of defending statutes that I sometimes don't agree with.
Right.
And that's a very important point, and it's a very difficult point, but it's something that anyone who's Attorney General has to understand. My responsibility is to represent the interest of the state. It makes it easier if it's something that I do have my heart into, but certainly from the standpoint of my responsibility, we go further than that. But the AG's office is a vast menagerie of things that need to be covered. We have multiple divisions. For example, we have an advisory division that provides legal advice and opinions to state elected officials and agencies. A lot of people are aware that we do have a consumer protection division that safeguards Hoosiers from predatory business practices by taking legal actions and violations of the Deceptive Consumer Sales Act. In that department, we oversee unclaimed property, which is a lot of people get to have fun with. There's hundreds of millions of dollars worth of property that people have lost over the time. And through our division of unclaimed property, we return over $1 million a month to Hoosiers who don't know that they have something missing someplace else. And that's one of the more fun aspects of what we do.
So how would citizens of Indiana find out if they might have a little bit of money stashed away somewhere that they weren't aware of?
Well, check out our website. Go to unclaimed property on our website of the AG's office, and it's a pretty simple piece of information. It takes a matter of seconds to type in your information and see if there is money or property that reports back. and it will give you an indication if there's something in your name and then further instructions on how to proceed. And we put these stations up all over the state from time to time to draw people in. And I've borne witness to people who received thousands of dollars on the spot. One very special moment was when we were able to recover the Purple Heart for a young lady's deceased grandfather.
Oh, my goodness.
And we were able to return that to her, and that was a very emotional return as well. Other things that we do in the office, litigation. We're lawyers, so we try and handle cases that are filed against the state. We pursue cases in the interest of the state. And an area that you're very interested in, our Solicitor General's office, is responsible for being our chief litigation policy advisor to me. And that's where many of the cases that go before the Supreme Court or the Federal Court of Appeals on constitutional issues, those come out of the SG division.
Well, that is very good information, and I hope one of our listeners will take us up on encouraging them to go to the unclaimed properties section on your website and see if they might have some Christmas money waiting there for them.
That would be nice this time of year.
Well, you were a prosecutor in Elkhart County for a number of years. So many of us, when we vote in the elections, see that we vote for county prosecutor, and then we also vote for Indiana State Attorney General. So how do the prosecutors in the various counties work in partnership with the Attorney General? Is there a partnership, or do they do something completely different?
Well, it's a yes and a no. It's an absolute partnership, but they are two different functions. The prosecuting attorney is the lead law enforcement officer within the county system, so that they are responsible for handling all of the criminal matters that occur within that particular county, and they have complete and autonomous authority over enforcing the Indiana Criminal Code. So they are state elected officials with a county jurisdiction. The Attorney General is a state officer, but we don't have original criminal jurisdiction on the Indiana Code. Those matters are for the county prosecutors to address. However, when a county prosecutor secures a conviction, and we're fortunate in this state that it happens quite frequently that Indiana prosecutors do their job and enforce the laws, if those cases are appealed, it's the responsibility of the Attorney General to handle the appeal of those decisions. So we do have a partnership. It's a very strong partnership in terms of working together to not only enforce Indiana's laws, but to help enhance the safety of the public.
And we've found, as we focus on life issues, General Hill, that there are prosecutors in some counties that are very receptive to hearing things that come up in their county having to do with abortion providers, et cetera, and some not so much. We have abortion facilities located basically in 4 counties in Indiana: Monroe, Marion, Lake, and Tippecanoe. And as we learned, I think it was a few months back, as you were preparing to make a decision about what to do about a piece of pro-life legislation that was being challenged, the prosecutors from 3 of these counties, who tend probably to be more favorable to abortion providers, asked you to step aside. Am I understanding that correctly?
Well, what happens in terms of a lawsuit getting its legs, the plaintiff in that case sued the defendant local prosecutors as an access point to court. So,
and that's pretty typical, right?
That's very typical. It's not necessarily that the prosecutor is going to get a judgment against them, but it provides a legal avenue for the plaintiff to enter into that litigation. And what those 3 prosecutors represented in a court filing was that they wanted to make the call on whether or not how to answer the complaint on their behalf as the representative of the state of Indiana. What we informed the prosecutors was that under Indiana law, it's the sole responsibility of the Attorney General to determine how a state action is going to be handled from a legal standpoint. And that's very firm in the code, and there's also case law that represents that. So while we do represent state agencies, we do represent other elected officials, such as county prosecutors, when they are sued in their official capacity, it's not for the county prosecutors per se to determine how that particular case is going to be managed or handled. That's still the responsibility of the state's Attorney General.
And while you took note of their concerns, I'm certain, knowing you, that you evaluated the facts and made a decision based on what you know the law to be and what the go forward might be and the possibility of success. I'm certain that's the way you took a look at it.
Absolutely. And in particular, if you look at the fraternity of prosecutors, I still consider myself a prosecutor. I was the elected prosecutor for 14 years. I was a deputy prosecutor for 14 years before that. That's who I am. I am very, very hesitant to do anything that's going to limit the role of the local prosecutor in terms of being effective in doing their job. So I take that quite seriously. And in that regard, I certainly provided counsel to the prosecutors in question in terms of what I believe to be the status of the law and how we would proceed with the case going forward.
Perfect. Well, this is Cathie Humbarger, and you're listening to iChooseLife News and Views. Our very special guest is Attorney General Curtis Hill. And General Hill, I'd like to turn a corner here. We've been talking a little bit in generalities in the first part of the program, but let's talk about a specific piece of legislation that's near and dear to the hearts of all of us here in Indiana who are pro-life advocates. And I think it's a good case to take a look at because we'll be able to understand how the courts work and a little bit about the process and how promising this particular piece of legislation might be. And I'm talking about the Dignity for the Unborn Act. This law was passed in 2016, and it was signed into law by then Governor Mike Pence. And what this law does is it makes any abortion illegal in our state if the reason for the abortion is for disability, race, or sex, or any of those protected classes that we're familiar with. The law also requires that the bodies of aborted babies be cremated or buried rather than being thrown out with medical waste. And just a little side note here, I was privileged to be part of investigating what was going on with the aborted babies' bodies here in the state of Indiana. It's a gruesome subject, but we found out that there was an abortion provider that was throwing the bodies of these babies into the sewer. And we also learned that the Planned Parenthood abortion facility in St. Louis was shipping the bodies of babies aborted there to a waste treatment plant here in Indiana for disposal. So that was the background for that law. None of us that are pro-life want to see the child's life taken, but the least we can do is treat that baby's body with dignity and respect. So walk us through the legal challenge, if you would, General Hill, and let us know where we are in the process.
Well, as you pointed out, the basic issue really comes down to the characterization of the entity. And by the entity, you and I, Cathie, share the belief that this unborn child is just that, an unborn child, a human being that is deserving of respect and dignity. And pro-abortion folks, and I don't want to speak for all, but it would appear that there is some suggestion that this entity is something other than human. And that is really at the rub of how these things work. House Bill 1337, which is what you were alluding to, was a challenge by Planned Parenthood on both of the provisions you mentioned, both in regard to discrimination in terms of picking and choosing which baby gets aborted and which baby doesn't based on a really frightening set of circumstances, as well as how to dispose of fetal remains and doing so in a way that's consistent with the character of the human heart. Planned Parenthood sought a preliminary injunction against the enforcement of both of these provisions, and that injunction was granted by the district court. The court also entered a final judgment, which meant that the new statute 1337 was prohibited from taking effect. So that's where the challenge comes into play. The law is established by the legislature, signed into law by the governor. The plaintiff steps forward and says, we want a preliminary injunction to freeze out any enforcement of this statute. That gets granted. They move forward for a permanent injunction. So the status is that law, which was enacted back in, I believe, 2016, has not been in effect because of the injunction to keep it from moving forward. Since that time, we've been involved in the legal process, and our argument is that the laws that establish the right of an abortion, Roe v. Wade and others, protect the right to decide whether to have a child, not a right to decide which child to bear. So it's appropriate in our view to outlaw abortion on the basis of disability or race or sex, because in that situation, you're not deciding whether to have a baby. You're really deciding you don't want to have this particular baby. Mm-hmm. And that gets into some very sort of Frankensteinish viewpoints that are somewhat troubling. Now, the Seventh Circuit has agreed with the plaintiffs, and thus far, the law has not gained legs in that sense. With respect to the disposition of the fetal remains, the theory was a little bit less about the right of abortion and more about the right of regulating Planned Parenthood as a medical entity. These arguments come back to a focus on the right of abortion because both the District Court and the Court of Appeals ruled that given the right to abortion and the lack of fetal rights under the 14th Amendment, the state does not have a legitimate interest in regulating the disposition of a fetus as if it were a human being. And again, as I started this conversation with you about, if it's not human, what is it?
Exactly. And this law does not prevent anyone from having an abortion.
No.
So that particular issue does not even bear on this case.
Which is why we have been hopeful that this would be an issue that would be taken up, because it doesn't directly address the issue of whether to have an abortion. That's not the issue here. It's, does this choice in these particular cases and for these particular reasons, is this an appropriate standard to be applied?
So if I understand correctly, when a law is challenged, it goes through specifically these two lower courts, and they have to listen to appeals if appeals are filed. Is that right?
The appeals go there, and they decide whether they're going to take them up. I mean, oftentimes you'll see a filing for summary judgment, which will essentially say there's not a legal basis to address a claim in this particular instance, so let's not waste time. So I don't want to say that they can't toss a case out quickly. The cases go there, they'll be docketed, but they can be removed very quickly if the court determines that there's insufficient legal basis for proceeding forward.
But they still have to look at the facts of the case.
They do have to look at the case. They do have to establish whether they want to go forward. But even cases that don't get accepted by the Supreme Court, they still look at the case on some basis to determine whether or not they're going to grant cert to review a petition.
So we're at the Seventh Circuit Court of Appeals, right? That's where this specific legislation is?
We're in the Seventh Circuit, and the Seventh Circuit granted a permanent injunction against us.
Okay, then the next step is to appeal to the Supreme Court, correct?
Well, we requested that. We have put in a petition for cert in the Supreme Court. There's I believe it's the Eighth Circuit that has a Minnesota case that has a conflict, and oftentimes you'll see the court take a look at one district has a particular position, and if there's another district that has an opposing position or a position that would be develop an inconsistency, oftentimes we may see the court take a look at pulling those cases in so that they can settle the distinction between the two circuits. So we do have a petition that we have filed. We're hopeful that we'll get some type of favorable, well, we certainly want a favorable response, but we anticipate that sometime, possibly after the first of the year, we'll get some indication of the court's position on this.
So do you have a ballpark idea of how many cases are appealed to the Supreme Court on an annual basis?
I don't know the number of cases that are appealed to the Supreme Court. I do know that it is a very, very, very small number that make it through. There's certainly a high bar on what it takes to get a case accepted by the Supreme Court, and that would make sense given the nature of what's going on.
So we cannot be assured that because this case has been appealed that it will be heard by the Supreme Court, but we certainly want to pray to that end and hope that that is the final outcome. But I think it's instructive for us, General Hill, to understand that just because we think that we have Supreme Court justices that may be more favorable to hearing an abortion case in terms of the outcome, that doesn't necessarily mean they'll even hear an appeal. And if they don't, the lower court ruling stands. So we need to keep that in mind. And that reminds me, as we tape this, just yesterday, the Supreme Court announced that they were not going to hear a case that had to do with funding Planned Parenthood. Could you fill us in a little bit on what happened and if you think that will have any impact at all on the case that you are in the process of appealing?
Sure, and we're still taking a look at that case that just came out, but it does center on the issue that people are aware of, the idea of federal dollars going to fund Planned Parenthood, which then ultimately supports abortions, and there are varying viewpoints on that particular issue. But this case had come down, and it was one of those examples of a case that seemed to be ripe for the court to address because, again, the case involved a split of a couple of districts. And you're right, there is somewhat of a naivete, if you will, of folks in this nation who think that the political process involved in selecting Supreme Court judges provides them with an automatic on what's going to happen in terms of a review. So the fact that we just saw Justice Kavanaugh confirmed following Justice Gorsuch, and so ideology-wise, it would appear that there are 5 conservatives to 4 liberals on the court, and therefore that means that any type of an abortion case is now going to get a look, and it's going to be a matter of time, and we're just going to reverse Roe v. Wade. There's a lot of people who have that very basic belief system that really need to slow that down, because that's just not the way it works. In this particular instance, the result is somewhat telling of how things are working. The Supreme Court denied cert in this particular case, and in order to grant cert, you have to have 4 justices say, yeah, we want to hear this case. This particular case, we now know which justices did not, because there was a dissent filed by Justice Thomas. That dissent by Justice Thomas was joined by Justice Gorsuch as well as Justice Alito. So that tells us that we were 1 vote away from having that case granted, the cert granted, and the Supreme Court hearing it. It also tells us that Justice Roberts and Justice Kavanaugh did not vote to look at that particular case. And if you further examine Justice Thomas's dissent, he goes into a little bit of an issue there, because he says he's concerned that his colleagues did not move forward because of the issue of the case being a Planned Parenthood case or an abortion case. And he believed that it was appropriate to move forward to the Supreme Court because we had a particular problem with needing to settle a split in these 2 districts on an important issue of law. So I think that's important. Now, what this might suggest is that just because there are 5 conservative viewpoints on the United States Supreme Court does not mean that every issue that might be considered a more conservative viewpoint issue is going to get a look. These are 9 individuals who examine the law as they see it, and they're going to make determinations based on their background, on their knowledge, and on their belief of how the system works. So you asked how this bodes well for us in some of the cases that we have pending. We're going to be taking a look at whether or not this particular court at this particular time has the stomach to take on issues that have to deal with abortion rights in this country. And it may be that they're picking and choosing the right cases or try to stay away from cases that they don't think are right. Each one of these individuals might have a distinctive difference of how they view that. But it's not automatic, and we have to watch very carefully. We're hopeful that we've got some issues that are pending that the court will take up, and once taken up, we're hopeful that they would find favorable.
I want to touch briefly, if we can, about a case of another kind that's pending in the courts. Regular listeners to this program know that we've been following the Whole Woman's Health filing for a license to open an abortion facility in South Bend, and we've been following that process through the Indiana State Department of Health. But they've also filed a lawsuit challenging several of our laws that established regulations for abortion businesses operating in Indiana, and they're very common sense laws. We're talking about things like patient notification, parental consent, licensing, inspection, some of the things that other businesses take for granted that they're going to need to comply with. How concerned should we be about this lawsuit?
Well, it's a great question. We and other states have prevailed on a number of the challenges that they're raising in the case, and they appear to be using the Whole Women's Health versus Hellerstedt decision from 2016 to try to reopen the door on some of these matters. There are dozens of regulations they're challenging, but we're hopeful that on issues that have been litigated in our favor in the past that will continue to prevail. I think in August, we filed a motion to dismiss that case because we believe that Whole Women's Health does not have a license in Indiana, so they don't stand to actually suffer any injury from the abortion regulations. The federal lawsuit includes challenges both to the abortion regulations and to the clinic licensing regulations. The clinic licensing matters are happening administratively, and that's being handled by a different part of the office. But our view is that until they get the licensing matters settled, they don't have a claim to pursue in federal court. So
seems reasonable.
Yeah, so we'll see. I think that's where we're postured at this particular point.
I don't want to end our conversation without a comment from you about the importance of the judges that are sitting on the bench in the lower courts. I know that President Trump has tried his best to fill as many of those vacancies as possible, but this is why it's so important who we vote for president, because the President and the Senate decide not only the Supreme Court nominees, but all those lower court nominees?
Well, elections matter. This is a primary thing. The shifting in the power at the federal level is something that we have to certainly watch, and the importance of our judicial picks at not only the Supreme Court level, but clearly the district level is important, because with Congress seemingly abdicating their responsibility more and more to get things done, the shifting balance of power has grown to the courts, unfortunately, because the courts should not be legislating, but there's a huge vacuum in Washington, and sometimes there's an expectation that we can fix that by the courts. Well, I think that people who think like you, Cathie, and certainly me, we view our courts as an important vanguard of the public safety and the public interest, but not as an entity that is designed to effectuate law and policy. They are to interpret, they are to determine disputes, and we feel comfortable in that regard. And it's imperative that we have people who understand that way of thinking that are on the bench. I'm concerned about a lot of what's going on in law schools across the country in terms of the indoctrination of law students and therefore young lawyers, and then ultimately people who will serve on our bench. And I've seen a decisive shift in the approach that youngsters are being taught in law school. I think we need to be concerned about that as well. So it's imperative that we do stay involved in the political process from our local elected officials at the city council level all the way to the presidency of the United States, and make sure that we understand and do our research on who it is that we're supporting, why we're supporting them, making sure that we don't get so stuck on ideology that we don't understand how to get things done, but also recognize that principle and what we stand for has to mean something. And we need to make sure that we understand what people do stand for, and if they take a position that they can defend it. Doesn't mean we always have to agree, but we always should be in a position to respect the position that's coming from someone else, because it's coming from logic, it's coming from a solid thought and argument, and a basis of understanding.
Well said, General Hill. This is something that all of us could take a lesson in. I think civility's taken a hit over the last couple of years, at least. So we want to thank you for always being thoughtful, reasonable, and approachable. We certainly appreciate your wisdom and experience on this issue and so many others. I will also ask our listeners to pray for you and Teresa and your kids, because you're in the tip of the spear.
Well, Cathie, I want to thank you for your constant prayers for me and my family. I feel it. I want to thank the folks from this state for their support and for their prayers. The power of prayer is real. The power of God and Jesus is very real, and we need to do more that we can for each of us as individuals, and for us to convey to our neighbors that we need to turn to God for guidance.
You've been listening to iChooseLife News and Views. If you have questions about this program, or if you'd like to support the fight for life, please call 260-471-1849 or go to iChooseLife.org, because without the right to life, no other rights matter.